Or fired for not getting vaccinated. That's what happened to Theresa Mulderiji, who refused the jab after the company she worked for implemented a mandatory vaccination policy. The matter was referred to the CCMA, where it found the company actually acted fairly. Well, to weigh in on this matter, Labour lawyer Gavin Stansfield joins us now via Zoom. Gavin, thank you so much for joining us. The CCMA found that Gold Rush, and that's the company that we're talking about, decision and vaccination policy was substantively fair. Legalese, what does this mean in layman's terms?
Good morning, Annika. Substantively fair, in essence, means that the CCMA has upheld the reason for the dismissal. There are two bases upon which the fairness of a dismissal is judged in terms of South African employment law. The first is a procedural one, and the other one is one of substance. Procedure, as the name suggests, did the employer follow a fair procedure prior to dismissing the employee? And the substance, being the important one, was there a fair reason for the dismissal? And that's exactly what the CCMA found.
When you look at the judgment, the complainant in the matter says that her right to bodily integrity would be violated should she be vaccinated. But the judgment actually found that you have a right to really protect your fellow employees, and that overrides this. Would that be a good assessment?
That's exactly right. I think that it's always, we know, with mandatory vaccination, it's a question of weighing up competing interests. On one hand, the interests of the individual, the Section 12(2) right of the Constitution, which she raised in this particular instance, which is the right to bodily integrity. But then we know that there's an important set of rights and obligations on the other side that the employer is faced with, and that is the obligation to create a safe working environment, not only for yourself, but of course for fellow employees, as well as any third parties who may enter the premises, and or in the case of employees who travel, the premises of third parties of clients whom you may attend or visit. So that's exactly ultimately what happened in this particular instance, is that the CCMA arbitrator found that when weighing up those particular rights, the rights of the employer in this instance to create that safe working environment must trump the rights of the individual.
To be fair, the company spent 3 months consulting with employees. It gave them a contract or a certain, information which they had to sign to acknowledge that they had read the vaccination process. There was quite a lot of consultation with both workers and unions.
That does seem to be the case, Annika, that consultation did take place, and the consultation seems to have been widespread across the business and extensive. So that certainly does appear to be the case if we look at the facts of the CCMA arbitration award.
One thing that I do have to ask you is this the end game, and is this precedent setting, and what needs to happen for other companies to follow suit?
I think the first point that needs to be considered within the context of precedent, and judicial precedent in particular, it needs to be emphasized that this is a CCMA award. The CCMA is not a court, it is an administrative tribunal, and as such, its awards do not create legally binding precedents either on companies and or in fact on fellow commissioners. For example, this award will not create a legally binding precedent on any commissioner who may determine the same issue in another matter going forward. What we really need to come out of the courts, and the Labour Court in particular, is precedent-setting authority, which, of course, it's imminent. In fact, I think I'm aware that there's an argument tomorrow on the 27th of January in the Labour Court involving Solidarity, where they are in fact challenging a mandatory vaccination policy. So until such time, that's not to say that the CCMA award is not persuasive, and in fact it certainly gives us an indication of what the CCMA's thinking might be. But until such time as we see authority emerging from courts of a higher status, the Labour Court and even the Labour Appeal Court, even the Constitutional Court, ultimately, this award doesn't create binding judicial precedent.
Okay, I'm sure we're going to be seeing more of these cases in the CCMA, and as you say, going up into the higher courts. Thank you so much. That was Labour lawyer Gavin Stansfield.